Good day, everyone. Eric Olsen from Helps on YouTube Live. Trust you can hear me. Good to have you here. My name's Eric, 74, founder of Helps. Helps is a national law firm, and our first mission is to represent seniors who have debt they can't afford to pay in order to stop debt collectors from harassing them. So if you're a senior, if you owe debt, even if you're current on it and you're worried if you stop paying, you're going to get harassed, there's means by which the harassment can stop. And our second mission is to educate seniors how they can maintain their financial independence. And you can put questions in the chat feature, and I'll direct them. You can direct them to me there, and I'll try to answer them. And then I also have a list of questions here that I've got. Okay, first person contacts us from Maryland, and they say, a creditor is filing for garnishment. I'm on Social Security disability because of permanent disability. Well, we're going to talk to this guy, and we're going to tell him he doesn't need to worry. If he's on Social Security, any form of Social Security is protected. Can't be garnished, can't be taken from you. Then you might ask, well, what happens if it goes into my bank account? Is it protected then? Yes, it is. There's a federal rule that was passed back in 2012 that provides that if someone sues you, they can't garnish you unless you're served with legal papers and they get a judgment. Okay, so if you haven't been sued, you just can't get garnished out of the blue. But if they were to sue you and get a judgment, and they happen to know where you bank, which isn't that easy, but if they did, under this federal rule, the bank has to examine where your money came from. And if it came from a federal source like Social Security, they take that sum times two and protect it. Now, be sure and tell me if you can hear me okay? Because I don't have my headset on. I can get my headset on if I need it. Just a minute here. So I'll give you an example. If you got $1,200 in Social Security, $1,200 times two, $1,200 each month times 2 months would be $2,400. That sum would be automatically protected from garnishment by your bank without you having to do anything. Now, the bank manager doesn't know the rule. Definitely the teller doesn't know the rule. But there's a department in the bank that deals with garnishments. They know the rule. You don't need to call the bank and tell them about it. They understand. Okay? Now, so you don't need to worry about losing your money. Now, what happens if you had a pension? Okay, well, they can't garnish the pension, and if the pension is going into the same account to which your Social Security goes, remember, twice that sum is protected regardless of the source of funds in the account in the event of a garnishment. So if you got $1,200 in Social Security, if we go with our example, times two would be $2,400. Let's say there was $1,000 in that account from a pension, okay? That would be completely protected from garnishment in the bank account as long as the balance in the bank account is less than $2,400. Doesn't matter where the money comes from, okay? Now, if you happen to have more than that in the account, the excess could be held up, but then you can file what's called a challenge to garnishment or claim exemption, have it released. We help people do that if it happens, and it's very rare that that's necessary. See, when people find out about Helps, they enroll, okay? And we enroll you over the phone. We don't turn anyone away. The cost is absolutely minimal. You give us your debt, your collectors you owe money to, or your creditors. Okay, and we need the name, address, and account number. We don't need the balance, and we're going to send a cease and desist letter out to that collector. Now, if you happen to have been sued, you're going to get us the name and address of the attorney. We need a copy of the lawsuit, usually just the first 3 or 4 pages. We'll send a letter to the attorney who sued you, let him know that your income is protected, you're not going to pay the debt. So you're going to be fine. Now, if you did have more money, like I said, in there, than twice the amount, you're not going to lose that. A claim of exemption or challenge to garnishment can be filed to get that money released. And so at any point, if you have questions or after listening to me talk today, you're welcome to always call us at the number below, okay? 855-435-7787. I promise you, a lot of the things you're going to hear today you're not going to hear on other channels. You know, why is that? Well, if you've been listening to me for a while, you understand that, you know, debt collectors or companies that help people with debt, okay, debt management companies, debt settlement companies, they don't, as a practice, ask questions about your source of income of a senior. They don't do that. Or if you are a senior and they know it, they don't tell you that your income is protected. The internet is full of articles advising seniors about with debt problems what to do. And very few of those articles will say anything about the fact that their income is protected. And that also that there was a federal law passed in 1978 called the Fair Debt Collection Practices Act, which provides if you're represented by an attorney, collectors have to leave you alone. And that's what HELPS does. We send a cease and desist letter to the collectors you owe money to. And under the law, a debt collector can no longer call or send you demand letters anymore. They have to leave you alone. So that's what we do. We represent you ongoing so you don't have to deal with collectors. Now, is our help just one time? No, it is literally forever for the rest of your life. When people enroll in HELPS, they're our client ongoing, okay? Not just one time. So they don't have to, why is that? Well, because it's common for a debt collector, if they can't collect from you, to maybe sell the debt or assign it to a new collector. And you might get a new notice 6 months, a year, 2 years down the road. Let us know. We send a cease and desist letter. They'll leave you alone. You might say, well, why can't I file bankruptcy? Well, you could. You might be able to. I filed about 30 or 40,000 bankruptcies before I started HELPS. But the issue was seniors would come and talk to me, and I tell them, you don't need to file bankruptcy. And the cost was very expensive. It's not unusual for a bankruptcy to, minimum be $2,000, sometimes $3,000 or $4,000. And if you don't need to file it, why file it and go through that headache? A lot of seniors don't want to do that. Okay, they don't need to. Another issue is, sometimes bankruptcy can get you in a problem. And sometimes I talk about how bankruptcy can make a mess of things for you. But, if your only income is Social Security, pension, disability, VA benefit, probably have no need at all to file bankruptcy, okay? Can I give a membership as a Christmas gift? Well, I don't know. The way people, when they enroll in HELPS, it doesn't cost any money up front. Normally, what it is you start payment 30 to 60 days in the future. It could be $40 for 24 months, $20 for 24 months free thereafter, or $30 for 24 months, $15 for 24 months free thereafter, or $20 for 24 months and $10 for 24 months free thereafter. The reason it goes down and the reason it stops is because at some point, the problem simply goes away. But we still represent clients from 12, 14 years ago when HELPS was new. And occasionally we'll get a call from them. They might have a new problem. Sometimes people incur a new debt for whatever reason. We're going to help you. We always want you to talk to us if you're worried or scared. Okay? Judy, who pays the attorney? The creditor. I received a bill from an attorney representing the creditor. I'm assuming the law is the same for the attorney. If an attorney represents a creditor, normally the attorney does that. He might do it on a contingent fee, where, in other words, he gets paid a certain percentage of if he's able to collect, or he might get paid a flat fee each month to represent all their cases. Okay? That's who does it. You don't. There might be an instance where if you get sued, there's a provision that you might be responsible for the attorney fees if they get a judgment. But so what? You don't have to pay it. You're what's called judgment-proof, which means they can't touch your income. It's protected. State law is going to protect your assets in almost every case. Okay? So you ask me, okay, well, Eric, I understand my income's protected. What about my car? What about my house? What about my my bedroom set? What about my dishes, computer, TV, lawnmower, whatever? Okay, states have different laws that protect a certain amount of equity in property. So much equity in a home, so much equity in a car. But as a practical matter, it's not the practice of consumer judgment creditors to go after a person's personal property. That's, a car, furnishings, whatever. Even if they happen to have equity in that item more than what the state allows as an exemption. Okay, they don't do it. Same thing with equity in a home. We just don't run into that as a problem. Okay. So what is the landlord letter? Well, some seniors are worried about their credit and they want to worry about being able to rent a place. And so what we have is we have a letter that we call the landlord letter that we'll furnish to any senior, whether they're a member of HELPS or not, that explains to a prospective landlord that the senior may have negative entries on their credit, but all their money is protected, available for their rent, can't be taken from them. See, a lot of landlords, they don't understand, they worry if someone has bad credit, they could get sued and they won't be able to pay their rent because someone could garnish their wages. But seniors don't have wages. They have retirement money, Social Security, pensions, which is protected. And so the letter explains that to the prospective landlord, so the landlord understands that even if the tenant has negative entries on the credit, the money's going to be available. And so we suggest to seniors that are going to apply for a new place, before they pay the application fee, to show that to the prospective landlord or whoever's taking the application. And then they can tell you, oh, that's good, I didn't know that. Or they can say, well, we have, corporate procedures, and you might save yourself a filing fee, okay? An application fee. Okay? And then on top of that, HELPS has a program for clients that have been part of HELPS for more than 90 days. It's called 7 Steps to a 720 Credit Score. And that program is free to our clients, and you can rebuild your credit within 1.5 to 2 years. Okay? Your credit is based on your recent credit history. The fact that you didn't pay your debt, when they write it off, it gets old, and they look at your recent credit to establish your credit history, so you can rebuild your credit. For a lot of seniors don't worry about that. They're not concerned about that. But if you are, we do have that program available, and it's free to our clients that want to take advantage of that. So this guy writes us from Texas, and I kind of like this. Sometimes people say the really sweet things. This guy says, or they're wise. He says, I need help with debts. He says, I never borrowed money before, and now I'm sorry I ever did. Well, we can help the guy. Yeah, he's not going to need to worry. Okay? So if you're worried about these things that we're talking about, please call us. You'll feel a lot better after you're done talking to us. Okay? This guy contacts us from Texas, and he says, just been sick. I'm diabetic. I can't even walk that much. I'm going to feel lightheaded and also anemic. And have high blood sugar and struggling a little bit now. Well, okay. I mean, we don't give medical advice here, but we can take the worry and the strain of debt off your plate. Okay? You can take the worry. And a lot of times that will go a long ways to making you feel better. Yeah. Yeah, it is possible to rebuild credit. We started doing this a couple of years ago with Phil Tyrone and his company, 720 Credit Score. I just did a video with Phil the other day. In fact, I need to get him on this channel soon. Anyway, again, when I first talked to him, I said, well, what about a person who had like $800 or $900 in income, minimal? Can they rebuild their credit? He said, Eric, absolutely yes. Yeah, I don't know why you'd want to. A creditor, if they were going to really look at your situation, if your income was too low, even though you do have good credit, they wouldn't be willing to loan you money, but it could help you if you wanted to rent or something like that. But, so if you want to rebuild your credit, you can do that. You don't have to. We don't take a position on that. That's up to you. So this guy calls us and he says, I was divorced, looks like about almost a year ago. In that settlement, I had to give my Social Security monthly check to my ex-wife. I got all the bills with no income to pay them. I mistakenly thought I had a job at that time, but it did not happen. Well, okay, first off, if you're not sure the legality of you giving all your Social Security in a divorce decree, okay, but that would be unusual. But if you have bills and you don't have any income, no one can touch you, okay? I've been living with my granddaughters and brother all year. I've not been able to find a job. I have no phone service. And it looks like he changed to have the Social Security come back to him. And he received a petition for contempt summons. We don't represent people in court. We don't give legal advice. This guy I'm going to tell me needs to see an attorney locally, or maybe the attorney that worked on his divorce. They could have awarded him support, so he was supposed to pay support, but technically it's not possible to assign the Social Security check to an ex-wife. Now, if you are, I'm going to get in the weeds here a little bit, but if you do owe past child support, it is possible for the person you owe child support to file a garnishment on your Social Security and take as much as 60% of it. But they're not able to, in my experience, able to require you to send the check to be diverted to you. They can order you pay a certain amount. So this is a little bit unusual. But sometimes, often judges do things that aren't right or legal. Okay, this person, I'm going to use this next scenario as kind of an example. He says, is my home protected? I'm in New York. Okay. Well, almost every state has exemption laws that protect a certain amount of equity in a home, and in bankruptcy or otherwise. And then if your state doesn't have an exemption, which very few don't, then there's a federal exemption in bankruptcy that protects a certain amount of equity in the home. But for example, this guy lives in New York. It's like $205,000 in Manhattan, Queens, Bronx, Richmond, in certain counties. And then it goes down to $170,000 in a couple other counties, and then in counties, in other more remote counties, it's only $102,000. Now, why they did it that way? I suspect they did it is because they wanted the exemption to be higher in the counties where the property values were higher and lower where they were lower. But if someone were to sue you and get a judgment, let's say you had a home that was free and clear, and it was worth $300,000, and it was in Manhattan, okay, apartment or whatever that you owned. So you'd have an equity in it almost $100,000 over and above the exemption. Does that mean that if someone sues you and gets a judgment that they're going to try to take your home? No. I mean, it's theoretically possible, but they just simply don't do it as a practice for a lot of different reasons, okay? So, now your home and your other assets are going to be okay. We go over that with people if you have questions. Once again, we don't give legal advice, we give legal information. We let you know. Okay? This person writes in, they say, well, I'll answer the question here. Do I have to pay for a timeshare that I can't sell? No, don't pay it. Don't pay it. Remember, if your income is protected, they can't do anything. Are they going to sue you? It wouldn't matter if they did. But I think I've explained before, a few years ago, I asked my partners, I said, do you guys ever remember, my former partners, do you remember any instance where they filed thousands of bankruptcies? Do you remember any instance where a timeshare has ever sued one of our clients that came to us for bankruptcy? And everyone said, no, Eric, they never sue us. They don't. It wouldn't matter if they did, but they don't sue. Okay? So, but even if they did, they got a judgment, your Social Security, your income is protected. So you don't have to pay for a timeshare. In fact, at times I see companies advertising to help you sell a timeshare. And in my opinion, they're scammers. Even the law firms are. Because they know that these companies don't sue. Or they try, but especially if you're a senior and your income's protected, you don't need help on selling a timeshare. Just stop making the payment, let it go back. Sometimes they'll send a letter saying, okay, sign the deed over to us, but we need an extra $1,000 or $2,000. You can sign the deed and send it back to them, but you don't need to pay them any money. Just let them take it back. Okay? So don't worry about a timeshare. This person writes in, they say, when time is running out on an old debt to legally drop away from your credit bureau, the original creditors will sell your debt to other sleazy debt collectors for pennies on the dollar. I'm sure when the statute of limitation runs out for older debt, it's most likely different in each state. Yeah, sometimes a debt collector will try to report on your credit for an old debt that's already really old. You can contact the credit bureau and dispute that. There's a way to do that. If you're part of that 720 credit score program, it tells you how to do that. But there is a statute of limitations which means a creditor that you owe money to has so much time in which to file a lawsuit against you. Could be 3 years, 5 years, 6 years. It depends on the state. And it's normally from the time when you last made a payment on the bill or when the payment was, when the bill was incurred, when it first became due. But once again, I've told people sometimes you could get sued by 1,000 different creditors. If your income's protected, you don't need to worry about it. You don't need to pay it. And then if you're part of helps you get us a copy of the lawsuit, we're going to send a cease and desist letter, or we're going to send a letter to the attorney who sued you, letting them know that your income is protected. And we're going to call you, remind you, and explain again why your income is safe and why you don't need to worry about this. We don't want you to worry. So, Linda asks, as a property owner, if the husband goes into a nursing home on Medicaid and passes away, we'll have to repay Medicaid if I sell the property. It depends on the state. It kind of depends. There's probably ways to avoid that. Okay? There's so many things that can be done. It's not a pat answer. So, say, for example, you own the property with one of the kids as joint owners with survivorship rights. Okay, your husband passed away. Now it's owned by you and your children together. And when you pass away, then it automatically goes to the kids. There's no probate. Or if you own the property and you've got a lot of equity in the property, he passes away. I mean, you could look into what's called a reverse mortgage to pay off any existing mortgage or give you access to equity in the home to supplement your income. So there's a lot of answers to be able to help seniors that are struggling, facing these debt issues. This person writes in, they say, this weekend I just had all my savings taken and put on hold on both of my savings accounts for a total of $21,000. This is from a credit card debt from 15 years ago. I haven't received any mail or phone calls about this debt and hasn't shown on my credit report in the last 7 to 8 years. My credit is good. I bought a home and vehicles and nothing has come up. I just don't understand this. Well, we're going to want to talk to this person. What appears to be the case is someone had sued them. They had a judgment against them. Now, a judgment in some states is only good for 6 years or sometimes 10 years. A lot of times a judgment might be good for 10 years, but it can be renewed for another 10 years, maybe renewed again. Sometimes there's a limit to, so this judgment apparently was from years ago. It's still valid. It's still sitting out there. If you bought a home, should have shown up on a title report. But anyway, there's a judgment, and for some reason they found out where you work, and they filed a writ of garnishment on your bank. Now, if you have the money in your savings account, and that's not the account to which your Social Security is deposited, then that money is subject to garnishment. However, if the money in the savings account, if you can show that it came from protected funds like Social Security or a pension, in almost every state, you can show that information to the judge and they're going to order the money be released. And there may be other things you can do too. Okay? So we're going to caulk this person. We're going to tell them what can be done. Okay? So they shouldn't lose that $21,000. There are so many things that can be done to solve that problem. But part of the problem is if you don't do anything and don't do it right away, then they get the money and it may be too late to do anything. So this person contacts us from Indiana. It says their only income is they're 63 years old. Their only income is Social Security. Oh, it looks like they do get a little pension. And they've been sued. And when they got sued, there was a court date. And they want to know, do I have to go to court? Well, if you read it carefully, the court date is if you're going to contest the lawsuit, if you're going to fight the lawsuit. But if you owe the money and you're not going to fight it, there's no need to go to court. And you just get a judgment they can't collect from you. And so we explain that typically you're not required to respond or attend. Yeah. And you have like 7 or 8 different credit cards. We explained what Helps did. And he asked, can I do this on my own? Yeah. Yeah, we have cease and desist letter templates. You can Google and find them, or you can get them on our website. But I'll tell that to like 100 seniors, and probably 99 out of 100 don't want to do it themselves for a lot of different reasons. And then she's been sued on top of that. And the note is from Paralegal. It says, sweet, sweet woman with lots of great questions. And she enrolled in Helps. She wanted our help. See, the cost of Helps is so minimal that, for a lot of seniors, it just makes sense. And then it's really nice that you have always someone you can call and talk to if you're worried. That's 99% of our phone calls we deal with is explaining why you don't need to worry. Well, okay, you might say, well, gee, if 99% I don't need to worry, maybe I just shouldn't worry. You can, yeah, you don't need us, just don't worry. But a lot of people want to understand why they don't need to worry. Okay. So sometimes people ask me questions that I don't know an answer to, or I can just guess. Like this one, I live in Pennsylvania. How would I stop people from living in an RV right outside my house on a city street? Maybe call the police. There might be a limit to how long someone can stay in a certain place. They're different, you might have to get creative. Okay. So this person contacts us from Georgia. My name is, I'm calling to get information on how to handle this problem. Could you please call me back? This was back in June. So we called her on June 30th once, twice, then we called her on July 2nd, left a message again. See, when you call helps, you know, we call you back. We have we can find it, we try to reach people. Sometimes people in Enrollment helps at first contacted us years ago. And then they looks like we finally connected on September 17th, last fall. Or this fall, whatever. It says, is having an awful time trying to rent an apartment due to colorful credit. She watched our videos on YouTube, talked about Section 8, and it looks like we sent her some emails, and it appears she enrolled in helps. Okay. So here's another person from Georgia called us, age 75. They get about $1,250 in Social Security and a pension of a little bit over $600. So about a little bit over $1,800. She has debt and says it has inquired about bankruptcy. He had a vehicle that was recently repossessed. And he signed up with a debt consolidation company. He was paying him $175 a week, every 2 weeks. And he says he can't get a loan for another vehicle. And he said back on September 22nd that he'll call back after he reads our emails and if he's interested in enrolling. They called us later the same day. Want to know if he could give us his creditor information over the phone. You can. Most of the time when people enroll, we ask you to either text it, fax it, email it, or mail it. Okay? We need the name, address, and account number. We don't need the balance. It says it was explained to him that he will receive email instructions how to send the creditors to us when he enrolls. He asked about bankruptcy several times and was instructed to contact a bankruptcy lawyer in Georgia if he wanted to. And we also sent him an email that talks about bankruptcy versus helps. And then he called back again, looks like today. Can't remember, but it looks like he may have enrolled or is going to be enrolling. So, you know, if you have any questions, you be sure and call. You don't need to be embarrassed to call. Yeah, you know, half of seniors have incomes within 200% of the poverty line. They're classified as economically vulnerable. So they struggle. You have plenty of company. And when you talk with helps, we're going to be the best friend you ever had. You know. So even if you need to call us 2, 3, 4, 5, 6, 7 times before you decide to enroll or whatever, that's fine. We're happy to talk to you. We want you to be clear on everything, okay? Rick says, you mentioned in the past that you're not favorable to credit unions. I bank with Navy Federal. Any issues with garnishments with them, or are they up to speed on the federal? They're up to speed on the federal law. All the credit unions are that way now, I believe, finally. You know, that law back in 2012 protected, explained how it automatically protected your Social Security twice the amount. Sometimes credit unions were slow on board to get the message, but we used to have to deal with the problems. regularly, and then it got more rare, and then it was 3 or 4 times a year, and then it became a couple times a year, and then once a year. I can't remember the last time we had a problem with a credit union not understanding the law on garnishment, so they're up to speed. Now, if you owe money to the credit union that you're not going to pay, then they're going to take it out of your bank account. They're going to offset it. So if you're not going to pay your credit union, you owe money to them, change and have your money go into a different bank account. Okay? Connie says, Eric, is it good to have 2 checking accounts? Social Security pays for bills and worker comp pays for necessities. Is that okay? Well, you can have 100 different bank accounts. As long as you've not been sued, no one can take your money. Okay, but if you've been sued, technically the bank where the workers' comp goes, that's not federal money, so it's not automatically protected by the bank. They could hold that up. So I normally would tell a person, if you didn't want the odds, you didn't want to risk that being held up, just consolidate to have your money go into the one account to which Social Security goes. But you don't have to worry about that unless you're sued. Then it might be a good idea to do that. Okay? So this person contacts us from Ohio. I don't know what, I can't understand what the message says, so I'll go on to the next one. So this person is 69 years old, and they live in Connecticut, and they get minimal Social Security. If they get minimal in Social Security, they're going to get our help for free. She talked to us, and it says here that she had 2 other family members on the phone when she talked to us. We love to talk with seniors if they have someone else that want to be on the phone with them. It says he's living in an assisted living facility and has a leased car through Chase. The car was leased in June. He can no longer afford the car payment or the car insurance. He can't even drive the car anymore. It says they've attempted to work with the dealership. Car's worth $24,000, but only worth $18,000. They want him to pay the difference. He can't do that. Doesn't need to do that. He doesn't need to worry about it. It says they returned the car to the dealership last night. Good for them. It says she had previously spoken to Priscilla from our office. Okay. Priscilla doesn't work for us anymore. She did work for us, but it's probably been 8 or 9 years ago. Quite a few years ago. So yeah, we get a lot of calls from people that, maybe a while before they decide they need enrollment help. She said she has a good understanding of what we do, what we do for everyone else. Okay, and then we talked to him about he didn't need to worry about the car or the balance he owes on the car. We reviewed his situation. He's ready to proceed with getting enrolled, and we enrolled him. And the fees were waived. So he's our client. If he happened to get sued, he would get us a copy of the lawsuit. We're going to send a letter to the attorney who sued him, let him know that his income is Social Security. He's not going to have to go to court. He doesn't need to worry. He can call us at any time he wants if he's worried or has a question. That's the nice thing about helps. You can call whenever you want. So this person contacts us from California. The husband is 70. It looks like the spouse is 59. He gets about $2,250 in Social Security and a little pension of less than $200. She gets about a $1,000 pension. And they have a home that they owe 600,000. That's worth about 600,000, and they owe 325. So they got what, 275 equity in the home. But the homestead exemption in California is at least 700,000 or more. Okay, so the home is not at risk. It says my husband and I were going to file bankruptcy, but we held off from filing. I may have read this one yesterday, but I'll go over it again if I did. They want to know options other than bankruptcy. This is, we are started the process of bankruptcy, but after watching the video I'm on senior living, would think that your option is better. If you could call us back, please do. Says they did not realize that they would have to sell their 2 vehicles and live in a rural area. So selling the vehicles is not manageable when needing to go to town. They can't afford their credit card debt. He's in mediation. He likes the fact that his income is protected. They're not worried about a judgment lien. They don't need to worry about a judgment lien in California. If you do what's called homestead the property, then they can sell the property and the lien drops off. They get all the money out of it. They say, the emails they said, I want to thank you for all your information you sent. As we discussed, we had almost concluded filing a Chapter 7 bankruptcy. We don't feel comfortable doing that, doing what we were told. It wasn't really correct. I told the attorney we're going to hold off. We believe that we want to go with Helps Law Group. Would you need a list of our creditors for your own letters? How do we get started? So apparently they were told they needed to file bankruptcy. Okay, and there wouldn't be any problem with their home, but there could be a problem with their cars. If they had cars that had too much equity in them, if they filed a regular bankruptcy over the estate exemption, a trustee could take the cars and sell them and take the money and use it to pay debt. And the person said, well, I don't want to lose my cars. Well, okay, they could file a bankruptcy called a Chapter 13. And let's say maybe they had I'll just say 20,000 equity in both cars, over and above the exemption for a state. So technically, if you filed a Chapter 13, which is a form of bankruptcy where you pay a portion of all or a portion of your debt back, to be able to keep an asset that otherwise you would lose in a regular bankruptcy. So 20, and you do it over as long as 5 years, 60 months. So you take 20,000 divided by 60 months, it's about $375, $380. Plus you got to add in the trustees commission, which is about 10%, and maybe the attorney fees. They could have ended up with a payment of close to $500 a month. Okay, in order to keep those 2 cars. And they'd be in a Chapter 13 bankruptcy for 5 long years. And so the trustee or the attorney could have told him, he said, okay, well, you need to sell those cars, spend the money and get cheaper cars, and then you could file bankruptcy. Well, they don't want to sell the cars. So, I mean, they could make the decision, okay, we're not going to sell those cars. If a creditor sues them and gets his judgment, are they going to come after the car? If they have equity over and above the exemption, it's theoretically possible, but it would be very rare for that to ever happen. It just doesn't happen for a lot of different reasons. Maybe the debt was in just one of the spouse's name, but the cars were in both names. There'd be a lot of reasons why there wouldn't be an issue, but we go over those kind of things with people. Will a bank intercept our funds from an accident and settle for an abandoned credit card debt before we can pay our federal and property taxes? Second mortgage. Well, most states will protect the proceeds of a car accident. Okay? That money is normally paid for pain and suffering, for future medical expenses and stuff like that. So most states have an exemption for you even to have to worry about it. Someone would have to sue you and have a judgment, and then have to know where you bank. And if you got a check, a settlement check, you could deposit in a bank where you normally don't bank. So there's a lot of ways that that money could be protected without you having to worry about it. Okay? And then if you're worried, you deposit the money, write a check out next day for your property taxes, whatever. There's ways to protect the money, so it wouldn't be an issue. But the stars would have to perfectly align. But even if they did, under state law, the money should be exempt and protected. So it's kind of like worrying, well, okay, if I go to Circle K tonight at 10 o'clock, could I get hit by a drunk driver? Well, it's theoretically possible, but it's practical that it's unlikely that would happen. Okay? Sure. How can you tell me how much of my equity is protected on my homestead in Alabama that's paid off? Well, it varies from state to state. Alabama's pretty low. 18,800 if you're single, and if you're married, 37,600. But like I said, um, even if you have equity more than that, a creditor, there's a lot of reasons why you wouldn't need to worry. Like maybe the debt is in your name, not in your spouse's name. Maybe if you're going to stay in the home. Maybe if you added your kid's name to the title. If someone sued you and got a judgment, it could be a lien on the home. They're not going to take the home, and then when you die, property is going to go to the other owner on the home, and the judgment lien drops off. Okay. We've got videos that explain that. So yeah, it shouldn't be an issue for you. Person contacts us from Florida. I usually talk about this every day. It says they get almost $2,000 in Social Security. And they say, I received an advertisement letter from a law firm indicating that a lawsuit was filed against me by someone. And it's a solicitation to represent me. Yeah. A lot of bankruptcy attorneys subscribe to a service that lets know if someone filed a bankruptcy. And they'll send an advertisement letter. Sometimes I talk to clients that get 3, 4, or 5 of them. Don't need to worry. So this is one of our attorneys. This is the notes from someone. It's just the potential client called in and we completed the intake. Now, what does that mean? When you call us, we ask you a bunch of questions like, your name, what state you live in, are you married, your age, how'd you find out about helps, have you been sued, are you buying your home or renting, what do you owe, what's it worth, are you buying a car, do you own a car, do you own any income taxes? Basic information that we need to be able to give you information you need to know. Approximately how much you owe in debt, okay? And then we read you what we do. And where does your income come from, like the different sources, so we can identify it as being protected. And she goes on, the attorney goes on to say they're both receiving only Social Security benefits as far as income, so it's all protected. The issue is he has 2 classic cars that are free and clear, that are in his name only. One is worth about a fair amount of money, and the other one's worth less. He says, we discussed the Florida exemption for vehicles, and he said if a creditor who has a judgment takes the cars, he's okay with that. Well, that solves that problem, but let's go on. But then I discussed the possibly selling them, both of them, and paying down his mortgage, because Florida has an unlimited homestead exemption. So he could sell the cars. If he's worried about, he could protect that money by turning it into protected money. He likes that idea and it makes sense. Then he wondered about possibly putting him in his wife's name or adding her name onto it. He could add her name onto it. I let him know oftentimes people add a spouse to the title, or he's talking about just transferring to his wife. Well, that might be just safer just to add her name to the title. He has $30,000 or a little more in credit card debt. Unlikely that any of those credit cards would go after those cars, no matter what he does. And that was on. And so he called back later that day, and it looks like he enrolled with Helps. He was just going to add his wife's name to the title. They've been married for a long time. She's technically an owner of those cars anyway. So this person contacts us from Missouri. He worked with Beyond Finance to reduce debt. We talk to Beyond Finance. We don't talk to them, but we deal with a lot of clients that have signed up with Beyond Finance. It's a debt management company. Now, when this person talked to them, did they tell him that his income was protected? I don't think so. If they would have told him that, they wouldn't have enrolled with him, and they wouldn't make any money off you. So they don't tell. Like I said, they don't tell seniors their rights. And he goes on. He says he got a lawsuit. He's buying a mobile home that's on land. No car or other assets. We read what we did, and she emailed, and she was relieved. Okay. So, why do companies, Happy asks, why do companies email offering credit cards with high interest rates and yearly fees? I gave a decent, because they want to make money off you. Credit card industry is a very lucrative industry. Okay. I'm retired. I don't have any savings, no assets. I'm living with my daughter for free. To reciprocate, I charged approximately $5,000 on my credit cards to replace her appliances falling apart 6 months ago. Can I enroll illegally? Yeah. We don't make any judgments on people and what they do. Okay. Okay, I'll end up with this one. A daughter called for her mom, who's 79 years old. Mom saw an ad for a debt consolidation company. and called them. She had been working with them and been told that she has paid off. I hear these stories, the same stories over and over again. Okay. Then she got sued. We really need to know what to do. We spoke to a bankruptcy attorney and he suggested we ask for a continuance and we have an appointment to talk with him the following week. So mom is 79 years old. She's on Social Security. She doesn't need to defend that lawsuit. There's nothing they can do to collect from her. Okay, listen to this. It says, we have been working to figure out what to do about the $23,000 debt. She can't afford and contacted a few different lawyers before coming across a YouTube video of this company. The pro bono lawyer we talked to basically told us that because she owed the money, there was not a lot we could do because she owned still mortgage a double wide mobile home that 4 adults live in. Did I talk about this one yesterday? A judgment in most states is not a lien on a mobile home. And then there's a homestead exemption. And then there's so many things that could be done to prevent there from being a problem. Bankruptcy could get, if she filed a bankruptcy, it could be, it might be like Brer Rabbit getting to a briar patch. It could turn into a mistake. Okay? So I'm going to end here because it's been almost an hour, believe it or not. Let me make a note here. I'll be here tomorrow, 2 hours later on Thursday. But in the meantime, if you have any questions or concerns or some of the things I've talked about make you think that you could use our help, don't hesitate to call 855-435-7787. 855 helps us or helps US. We don't turn anyone away. You'll be glad you call us. Okay? That's what we're here for, to help you. So please have a good day. Try not to worry. And God bless.